Hi, everyone. My name is Ashley Jacobson. I'm a disability civil rights attorney and a vocational rehabilitation counselor and disabled woman. And a couple of weeks ago, I hosted a webinar for attorneys and law students who are interested in the legal area of disability civil rights because we desperately need more attorneys in this niche area of law. And there tends to not be a lot of useful resources for attorneys who want to get started in this area of law. So I wanted to do something to help and provide a foundation that you can build upon if you want to serve the disability community. That being said, every area of law will be touched on by clients with disabilities, attorneys with disabilities, judges who are disabled. And so it is useful for everybody to know. But when I did that webinar, it was very long. And I realized that not everyone has an hour and a half to 2 hours to sit down and go through disability civil rights. So I'm re-recording this. And I'm going to try to condense it so that you get the most important pieces, but just know that if you have any additional questions, you can always feel free to reach out to me. So I'm going to go ahead and share my screen. There we go. That's the right one. Okay. So we did a little introduction. I'm going to go through the main facts and lingo and then dive into disability civil rights, some strategies for success, and you'll note that I also have other resources on my website if you want to learn more. Again, my name is Ashley Jacobson. I'm a disability civil rights attorney. My main areas where I represent clients include education law, employment law, juvenile law, and long-term planning through estate planning and things like that. But I would say the vast majority is education law and juvenile law with some employment law sprinkled in there. I also have a master's degree in a disability counseling field called vocational rehabilitation counseling, where I can assess people for reasonable accommodations in the workplace and in schools. And I can do that nationwide. I can also provide, expert consulting services as well. So I want you to think about your first memory of disability. Maybe you had a neighbor who used a wheelchair. Maybe you have a family member that used a walker after surgery, or a friend growing up who had seizures because of epilepsy. It's common to bring your experiences to the table when you're an attorney serving clients with disabilities. But you want to make sure that you recognize that each person experiences disability differently, even two people with the same diagnosis. So you want to evolve your understanding and how you picture disability in general and recognize that it is an incredibly diverse community. So a person can have a disability and not use any mobility aid like a wheelchair walker or a cane. Maybe that person is immunocompromised and has chronic illness, and so they are still wearing masks, even though many people have abandoned them, which is another topic for another time. But disability is different in everybody. So you want to have a good baseline foundation and then tailor that to each client and that client's individual needs. Quick facts. Everyone given the opportunity to age will have a disability of some kind. It's not meant to be a threat. It's just the reality of being a human being. It's the most natural part of the aging process. And people with disabilities are the largest marginalized community in this country, in the United States, with at least 1 in 4 US adults having some type of disability. But disability also crosses every group, whether, all racial groups, socioeconomic groups, gender identities, sexual orientations. So it's not uncommon to have to recognize that a client might be experiencing disability discrimination in addition to racial discrimination or gender discrimination. There are many disability rights laws in the United States. Disability civil rights are fairly new in the context of the human experience, which is why it's so crucial that we continue to fight for these rights, to keep them in place, to expand them where appropriate, and to enforce them. It is estimated that up to 70, now reports are saying even up to 80% in some facilities, in juvenile justice facilities or the juvenile detention system, have disabilities. So we are seeing a disproportionate number of children, especially children of color, who have disabilities in our juvenile detention centers. And 1 in 6 children between the ages of 3 and 17 years old have some form of developmental disability. Kids with disabilities are also more likely to have negative police and first responder encounters that at times can cause long-term catastrophic injury or even death. Um, this is also sadly the case for adults with disabilities. And kids with disabilities grow up to be adults with disabilities. And I only say that because very often people will show sympathy towards a parent who has a child with a disability or empathy towards a child with a disability, but then has no care in the world for adults with disabilities. And so there's this disconnect where when it's a cute little kid with a disability, people want to support them, you would think, though even lately that's been called into question in many ways. But kids with disabilities tend to be treated better than adults with disabilities. And they have these very unique experiences in every area of law. Because they can arise in any area of law, and especially if you want to be a disability civil rights attorney, you have to understand appropriate language when it comes to disability. Now, when I was in graduate school for my master's degree, they taught us that person first language was the best thing that you could use for people with disabilities. So it's saying they're a person first and their disabilities brought up second or later if it's relevant. And this was well intended by disability service professionals. And some people with disabilities do prefer person first language, but lately the vast majority of the disability community has made it very clear that they don't want disability to be seen as a negative or something that needs to be sugar-coated with the language we use. There's nothing wrong with having a disability or being disabled. In fact, disability culture is rich and vibrant and diverse, and people in that community have a lot of pride around being disabled. And so you want to use the language that the person prefers always. And it's really truly as simple as on a client intake sheet, state, do you have language that you would prefer we use when referring to your disability? Do you want us to go by your diagnosis? Do you like to go by person first language, identity first language? If you're not sure what any of those mean and you want to discuss it, let me know. But it's usually something that people, especially adults with disabilities, are aware of, and they have a preference when it comes to the language that's used. We want to be really mindful to avoid using terms like special needs as attorneys, in part because kids and adults with disabilities have said that they don't like the term special needs. It's a term that has been co-opted by bullies at school, used to target kids and adults who are disabled. And again, it's this flowery, sugar-coating language that kind of allows the user to imply, or the person who's hearing it to infer, that disability is this like hush hush thing that we need to sugar it up, make sure that it's more consumable to the non-disableds out there. And so just be really mindful of disability culture. And there's a way, as a disability civil rights attorney, I represent a lot of kids whose parents hire me to represent them. And the parents often have used the term special needs frequently because that's how they've been conditioned to talk about disability. And there are ways to delicately broach that, but what I always do is I will use the language that my client prefers, but I will explain to clients that in my court filings, I feel very strongly that using the term special needs is less beneficial for the client. And I explain why that is, and usually they're in support of me not using the terminology of special needs in court filings or on the record in court. So accessibility and inclusion, these are two big buzzwords, especially right now if you're hearing about all of the hubbub around DEI. But really DEI traditionally has included DEIA, which the A is accessibility, the I is inclusion. And so what is accessibility and what is inclusion? Accessibility is ensuring that there's equitable access to ideas, events, technology, programming, etc. So in the law, maybe you're having a Zoom meeting with a client and you're not clicking to put captions on the meeting. Very simple, quick accessibility tool, and it can really allow people to participate more in the meeting, to provide more useful information, to contribute more to the workplace. And if you don't have that, you're not reaching the people in the meeting, but also if you're not doing things like providing captions on your social media or your marketing materials, that's a huge area where I see a lot of lawyers missing out on great business because they're not reaching the over 60 million disabled people who are on social media in this country because they're not putting captions on their videos. And I'll note that accessible practices often benefit far more than just the individual who's disabled. Most people consume social media with the volume off or turned down on their phones. And so having captions on will ensure that people actually still consume your content and know what services you provide. But anyway, that's just one example of accessibility. And I have a whole YouTube video on the 8 A's of accessibility, which I'll get into a bit more later, but that can provide a good foundation for you to make sure that from start to finish, you have accessibility streamlined into your process, and then you can adapt it for each individual client as needed. So that's accessibility. What is inclusion? Inclusion is people with and without disabilities of all races, backgrounds, orientations, and identities have opportunity, fulfillment, access, and equity as active participants. It's not just they're invited to the meeting, they have a seat at the table. It's do they have the opportunity to contribute where appropriate? You, in the disability community, and certainly in disability civil rights, as well as in negotiations with opposing counsel, you'll have conversations about perceived invisible disabilities or disabilities that are not as readily apparent to a stranger on the street. So it might be somebody who has mental illness, someone with chronic pain, a learning disability, other chronic illnesses or autoimmune disease. And so traditionally people have used the term invisible disabilities versus visible disabilities. Visible disabilities would be things that are more readily apparent to a stranger on the street. So they can see that you're using a cane or a walker, or maybe you have tremors in your hands or your legs. But I personally don't like the term invisible disability because I feel like it centers the non-disabled person's perception of whether or not that person's disability is valid. And no disability is invisible to the person living with it. And I think if you start from that point, you are in a primed position to best serve all of your clients by recognizing that their disabilities are not invisible to them, it affects them, and that you want to ensure that they are guided through this process so that they can fully participate because their perspective is important and it matters. And so to say that someone's disability is invisible could come across as kind of minimizing their experience and dismissing how hard they work to adapt and to be resilient in a society that really wasn't built for them. We've had to create these civil rights laws to address the barriers that were unnecessarily built into the system that, once removed, allow a person with a disability to fully participate. Ableism. So what is ableism? It's really at the core of disability civil rights. Ableism is the term for when someone discriminates against, holds prejudice towards, or is biased when it comes to a disabled person. So what does it look like? So ableist language, it's not just the R word, though that word is becoming popular again due to some podcasters and comedians and people on social media who have no regard for people who are disabled. But it also includes terms that are often used in IEP or 504 documents or meetings, words like non-compliant, disobedient, slow, stupid. And if you're thinking, there's no way that a teacher or a paraprofessional would say these things, these are all things that I've professionally witnessed being said or documented in IEP or 504 documents or on the record at trial. So you want to identify ableist language so that you can address it immediately throughout the legal process and hold people accountable for it when appropriate. It also can look like restricting the independence of a disabled person unnecessarily, limiting opportunities, punishing for behaviors that go unpunished in other people. So we tend to see kids in the juvenile court system, they're being referred from schools and police to the juvenile courts more frequently than their non-disabled peers for the same behaviors. They're also facing harsher punishments than juveniles in the system who don't have disabilities. And Black and brown kids with disabilities face this at even higher rates. So it's crucial because it can affect them for their entire lives. I mean, the school to prison pipeline is another hot topic in disability civil rights. And I really encourage people to look into that if you are interested in learning more. But we want to make sure that we're identifying ableism so that we can stop it in its tracks, address it, and not allow it to continue moving forward. And when we stand up for our clients in this way, I can't tell you how much that means to them. It goes back to, I value you as a person, not just a client, and I won't tolerate for you to be treated that way. And they feel more confidence in you as an attorney and in themselves as a participant in the legal process. Briefly touching on disability culture, people with disabilities have always been around, but until recent decades, they were mostly isolated and segregated from the non-disabled population. And that just wasn't in schools alone. That was through the ugly laws. You want to Google ugly laws, and the institutionalization movement. If you're interested in learning about that, a great place to start is by searching about the Willowbrook School. You know, they've been forced inside, out of public view for a very, very long time. And it is only because we as disabled people created disability rights through awareness and advocacy that there is more awareness and acceptance of disability today. Though, as of late, there have been consistent attacks on disability rights, including 17 states suing to try to deem the Rehabilitation Act unconstitutional, which would mean that schools do not have to create or enforce 504 plans for students with disabilities, and vocational rehabilitation agencies are losing funding or they're being closed. And that is only going to increase if the law that helped mandate those agencies goes away or is deemed unconstitutional. And when they start with the Rehabilitation Act, if they were to succeed on that being deemed unconstitutional, very quickly, the next step will be them coming for the Americans with Disabilities Act or the Individuals with Disabilities Education Act. And so we cannot allow these disability civil rights to go away, especially now more than ever. But the picture that you're seeing on the screen here, disabled protesters have been at the forefront of advocacy for not just disability civil rights, but all forms of civil rights. And they also benefited from other civil rights leaders who supported their cause. And one way that disabled people advocated and created awareness that led to the Rehabilitation Act, which includes Section 504 being passed and the ADA being passed, was they would perform these sit-ins or these crawls where, because there was not an accessible entrance to the Capitol building, you're seeing people who use wheelchairs climbing using just their arms to get up these Capitol steps. And it still gives me chills to think about. It's incredibly meaningful, and it's something that we're seeing happening now again. And so I highly encourage you to follow some disability advocates on social media. If you go to my page, you'll see I post with a lot of them, and see how you can support creating awareness and ensuring that these rights do not go away, because they were so hardly fought for and they're so needed. Okay, so one area of disability civil rights, presence in the workplace. How will you/your child prepare while in school? So how do we challenge the stigmas and stereotypes that still exist today, especially as we prepare kids with disabilities to become disabled adults? And maybe they're going to college, maybe they're going to the workforce. But it's important that parents and kids have a realistic view that in 2020, not long ago, 80% of people with disabilities were unemployed, despite the vast majority being capable of and qualified for employment. That same year, only 40% of non-disabled people were unemployed. So we're seeing disproportionate rates of unemployment despite people with disabilities being highly qualified and talented individuals, because of hiring discrimination or retaliation for requesting reasonable accommodations at work. And, when we're looking at disability civil rights, there's an intersection between education and employment and juvenile law. Education and juvenile law tend to go hand in hand. And there are disability civil rights in schools that not only allow for kids to have individualized education programs or 504 plans, but also due process rights. So if they're disciplined while at school, there's a process that must be initiated to determine whether or not their behavior was a symptom of disability or not. And that if it is a symptom of disability, then they should not receive certain punishments, or certain things should be adapted to meet their needs. But then let's say the child grows up, works really hard, gets a job. Once in the workplace, most disabled people have horror stories, myself included, about being a disabled working adult with, supervisors or people who say or do ableist things. And so this can look like denying accommodations, retaliating against someone for disclosing that they have a disability. And what that typically can look like is maybe this person says to their boss, I'm having a flare-up of my rheumatoid arthritis. I need to go to the doctor, so I need to be out for the afternoon. And then that's now in the employer's head that, oh, this person is missing out on work, they're unreliable because of their disability, and we should start documenting things to prepare for them to be terminated. Whereas a non-disabled employee who goes to the boss and says, hey, I caught the flu from someone. I've got a fever, I need to take the day. They've missed the same amount of work time, but because their condition was seen as temporary and not a disability, they're treated differently. So you want to make sure as a disability civil rights attorney that you understand how disability civil rights evolve as these clients age. Maybe you start by enforcing their rights in school, and then as they get older, they come to you so that you could enforce their rights in the workplace. I do have a really great video on the factors that you should consider when disclosing your disability at work, the methods, the timing, the way to protect yourself. That's on my YouTube page. But if you want that information, feel free to let me know. As a disability civil rights attorney, you might get a lot of calls about IEP or 504 representation. So when we're looking at IEP or 504 representation, we're typically talking about a number of disability rights laws happening at the same time, as well as in employment law. There are always federal and state level disability rights that are being applied at the same time. So the first law that you want to be aware of is the Americans with Disabilities Act. This act states that you're considered to have a disability and disability rights if you have a condition that significantly impairs one or more major life functions, or you have a record of being diagnosed with such a condition, or people regard you as having a disability. So even if you don't have a disability, if somebody at work thinks that you do and treats you terribly because of that, you still have disability rights. But the vast majority of people fall under the first prong, which is a condition that significantly impairs one or more major life functions. That could be your activities of daily living, eating, cooking, grooming, sleeping, physically moving, but it also includes your ability to work. In employment, how you hold people accountable for ADA violations or Rehab Act violations looks a little bit different right now because of the administration that has come in and some of the changes that they're making or attempting to make. The Equal Employment and Opportunity Commission, or the EEOC, is in limbo, as is the Office of Civil Rights at the federal level. But as a disability civil rights attorney, I've reinforced that these laws are still in existence, and the best method for enforcing them has always been to sue in court. Always. The EEOC has rarely been helpful for my clients, as has the Office of Civil Rights. But the state level, Michigan Department of Civil Rights, they're still doing some cases, though they tend to not do quite as much either. But state and federal court has always been the method where I've seen the most success. And so as an attorney, you want to make sure that you're not forgetting the state level disability rights laws, because sometimes those are broader and don't have caps on damages, meaning you can get more money for yourself and the client if you include state level claims. So you want to search your state's disability rights law and make sure that you are equipped to answer questions about that. And you still may want to file with the EEOC, even if you don't expect them to do anything, because the way that some of the state and federal laws are written requires you to, quote, exhaust administrative processes before you get the right to sue in court. Typically, those administrative processes were filing with the EEOC and giving the EEOC time to investigate. And then if they don't pursue the case or they close the case, you get the right to sue letter, and then you file in court. And you have to file in court within a specific time period. So you want to make sure that you're well versed on the statute of limitations for both filing with the EEOC as well as filing in court once you get the right to sue letter. And right now, the EEOC has sent me emails saying that they're closing cases and that they're not issuing right to sue letters, or I haven't received them despite requests. So we're in this gray area where judges will need to decide have administrative processes been exhausted where the administrative process no longer exists? And that's where, as an attorney, you might need to be a little bit creative in how you explain that in a court filing. In education, one of the laws that I mentioned being a big one is the Individuals with Disabilities Education Act. It mandates special education services from ages truly zero to 3, all the way up through, in some states, 21 or 26 years old. It ensures free and appropriate public education, non-discriminatory testing, reasonable accommodations, that students are placed in the least restrictive environment, meaning they're not just thrown in a self-contained classroom because they have a disability. If they're able to participate in general education classes, maybe with some reasonable accommodations or with some resource room support, you want to make sure that you are not putting children in restrictive environments where they don't need to be, because that limits them not only in the content that they learn, but sometimes their outcome when they graduate with a diploma versus a certificate, as well as specialized curriculum or instruction and transition planning, plans for helping kids transition out of school into college or the workplace. The IDEA is a federal law. However, state-run administrative law agencies hear due process complaints. If you feel as though a client is not being reasonably accommodated or that their school is violating their disability civil rights, you can file what's called a due process complaint, and you'll want to search in your state for what that looks like. But it's typically has a cover form, and that form has these tiny little boxes where it says, explain the problems and facts. Explain the potential remedies, how you want the school to fix this. Very often I see parents make the mistake of filling that out on their own, submitting it, and then seeking an attorney. If that happens to you, it's important to note that you can amend that to add a more detailed filing that it resembles more of a lawsuit with a full timeline, with really specific facts about these disability rights violations and the laws that you allege are violated. And you can go through a due process hearing, which is like a trial. And that's the other mistake. Sometimes I get calls from parents who thought they could do this on their own, and then they realize, oh shoot, this is a trial where all of the evidence rules apply. I have to provide foundation before I submit exhibits, and I don't know how to do that. And so as an attorney, you might come in at any point in the process, before they file the due process complaint, right before the due process hearing / trial, essentially. And then, due to these due process proceedings historically favoring school districts in significant ways, sometimes in some states, they rule on the side of schools over 80% of the time. Very often, as an attorney, you have to explain to the client that the end goal is not necessarily to win at due process, though certainly we'll do everything in our power to do that. Usually the long-term goal is we're going through due process with the understanding that if it does not go our way, then we'll have a better opportunity in court to file an appeal of the due process results or orders from the judge, the administrative law judge or tribunal, and adding on other disability rights violations that you can add on in a lawsuit, such as ADA violations, Rehab Act violations, and state level disability rights violations. Due process trials or hearings are more about compensatory education. So maybe the student needs tutoring, or they're moved to a different classroom. It tends to not provide quite as much in monetary damages as in filing in court. So it's important that the client understands that as well. The Rehab Act is where Section 504 comes from. It mandates disability rights in federally funded programs, including schools. Schools sometimes act like 504 plans are for kids that don't have quite as severe disabilities, As a disability civil rights attorney, I tend to think that that's a red flag if a school says that, because they have different purposes, but it's not necessarily about the severity of the disability alone. Similar definition of disability as the ADA. Many federal and state laws follow similar definitions of disabilities, but you'll want to double check that for your state for sure. And to go back to Section 504 of the Rehab Act, that also applies for college students. So whereas the Individuals with Disabilities Education Act follows kids through secondary school, Section 504 tends to protect them once they're in college. And of course, the ADA applies as well. So disability civil rights attorneys will hear this a lot from opposing counsel and even from some judges. Okay, but why does this client deserve special treatment? They're requesting an accommodation. That's special treatment. Accommodations are not special treatment. Accommodations are not special treatment. I'm going to say it one more time. Accommodations are not special treatment. They remove barriers that are unnecessary from environments that lawmakers found were discriminatory. Period. They allow students and employees to show their true abilities by removing these unnecessary barriers. When you don't provide reasonable accommodations, not only are you not following the law potentially, but disabled employees and students aren't able to show their full talents and abilities. They're not able to contribute, and they spend a significant amount of time outside of school and work compensating, planning to face these barriers. Some accommodation red flags, things to look out for as a disability civil rights attorney. He can't have a disability, he gets all A's. Or she does well enough in school without accommodations. He doesn't need those in his IEP because we just provide that anyway. So why do we need to document it? As an attorney, I will always prefer to document reasonable accommodations and other disability rights. A person overcompensating or working themselves to the bone to get A's because they're facing discrimination at school does not mean that they're not entitled to disability rights in school. So you want to be able to have little comebacks, if you will, clapbacks, when these types of things are brought up with accommodations. And also it's important as a disability civil rights attorney to mention to opposing counsel and judges and attorneys that accommodations can benefit everyone. They are individualized to the person, meaning when an employer says, well, we don't want to provide an accommodation because then it sets a precedent, we'd have to provide it to everyone. That's not true. That's not the way the law is written. They usually know that, and they're saying that anyway. But it's important to say that accommodations are, first of all, low cost or no cost over 90% of the time. So they're not typically very costly financially. They also benefit everyone. So examples of accommodations that benefit everyone, making sure that there's not background music playing in the workplace, making sure that there is a Zoom option for Zoom participation, that you're providing captions in Zoom meetings and other meetings, allowing flexible scheduling when appropriate, even for kids in school, allowing students to use headphones or earplugs or loop earplugs that help with overstimulation, things like that. So as well as outlines or notes summarizing classes or meetings being available to everyone. Classrooms designed for everyone, benefit everyone. Some strategies for success as a disability civil rights attorney in IEP or 504 meetings: review materials and meeting spaces in advance and ask if the student and the parents can receive and contribute in those environments. Again, captioning software is typically free and easy to use. I've got instructional videos on my social media. Use image descriptions and video descriptions and recordings wherever you can Note that many schools are starting to get wise to the fact that disability civil rights attorneys are advising their clients to record IEP meetings and 504 meetings. They are enacting school-wide policies in their handbooks that require parents in some cases to provide advance notice if they plan on recording a meeting. It's crucial that as a disability civil rights attorney, you know what the recording laws in your state are, and the eavesdropping statutes in your state. If you're a one-party state, that might mean that if you're a party of the conversation, you don't need to get anyone's permission to record it. But in other states, you do need everyone's consent. So that's why it's really important that, especially if the school is putting up barriers to recording the meeting, that you know what options you have so that you can potentially use that as evidence later in court. Strategies for communication. As a disability civil rights attorney, you will constantly be learning from the disability community about the language they prefer and why, and it's crucial that you listen to them. Expand your daily interactions in person and online with people with disabilities, not just parents of disabled kids. You want to listen to actual disabled people about their lived experiences and what's worked for them and what they've appreciated in an attorney and service provider. You can search for hashtags like hashtag disability advocate to get really quick content in that regard. Be mindful about how you talk about, the child's disability, even if it's your child who has a disability, how teachers and therapists and your witnesses talk about disability, and ensuring that the child can participate in IEP and 504 meetings. Do your research before. I cannot state that enough. Make sure before the meeting that everyone knows what accessibility features are needed, any accommodations that are needed, and a great resource for evaluating accommodations is through a rehabilitation counselor. I have a master's degree in that field, and these are master's level clinicians trained to assess and counsel people with disabilities in the workplace, schools, home, and the community. Every state has a free vocational rehabilitation agency for as long as disability rights are in effect and around. So we want to fight to keep those. And remember, anyone can join Club Disabled at any time. I certainly am a great example of that. I ran a half marathon 2 months before I acquired physical disability. So it really can happen at any time. It's not the end of the world. It does take an adjustment, constant adjustment and adapting, but I think it actually has really made me better at my job because I can empathize with what my clients have gone through. I can empathize with what it feels like to be discriminated against based on disability, and I am better equipped at adapting the legal process to their needs. But that being said, disability is really diverse, and two people with the same disability might have completely different experiences. So you really have to truly listen to your clients in that regard. I have a video on the 8 A's of accessibility, which guide you through how to streamline your legal processes. It's free, it's on my YouTube. Just go to my page, you'll see the 8 A's of accessibility video there. And that will be a good starting point if you don't know where to start and you want to make sure that your law firm is accessible to clients with disabilities. Because again, this is an emerging legal area that is really financially lucrative and meaningful and rewarding. And we desperately need more people to do this work. Some other great resources, askjan.org. That's askjan.org. And they can allow you on that site to search for accommodations based on the work environment or the disability or symptom. Look for your local Center for Independent Living. They're great resources for clients who are disabled. Your state's vocational rehabilitation agency, and the CDC's disability inclusion resource page, though I meant to remove that because the new administration took that page down. as well as my social media pages at Ashley B. Jacobson. That tends to be a great place to start as well. And consume more disabled content. This will help you as an attorney identify emerging legal issues. There are many podcasts hosted by disabled people, and I've listed some amazing disability advocates to follow as well. Feel free to pause there. And just know, disability advocates and disabled people, we don't expect perfection from disability service providers, but we do want effort in understanding and empathy and accessibility. And as an attorney, I truly believe that if you don't ensure the legal process is accessible and you're not protecting a client's disability rights, you cannot be a zealous advocate for your client. I genuinely believe that. And so I just really commend all of you who have watched this far. And if you have any questions, I am here. I'm trying to get more attorneys in this area of law. So you're not going to bug me. Reach out to me, shoot me a text, send me an email, ask questions, and explore how you can serve the disability community. Thank you so much.